Dear students, today we are going to discuss about human rights courts under the Protection of Human Rights Act 1993. Human rights are commonly understood as inalienable fundamental rights to which a person is inherently entitled simply because she or he is a human being. India, being a diverse country with its multicultural, multi-ethnic and multi-religious populations, the protection of human rights is quite necessary for peaceful existence. It is indeed impossible to give an inclusive definition of human rights owing to its vast nature. However, the legislature have tried their hands in defining human rights as the rights relating to life, liberty, equality and dignity of the individual, guaranteed by the Constitution or embodied in the international covenants and enforceable by the courts in India under the Human Rights Act 1993. It is implicit from the definition that human rights are omnipresent in all legislation in our country, and it is duty of the jurist to read between the lines and enforce these rights for the betterment of the society. In precise, our judgment should be articulated in such a manner to accommodate human rights whenever it is required. The status of human rights is fairly high under the Constitution of India, which makes provision for fundamental rights and empowers Supreme Court of India and High Court to enforce these rights. The Indian judiciary, with its widest interpretation in observance of human rights, has contributed to the progress of the nation and to the goal of creating India as a vibrant state. The definition of human rights can be found under Section 2, Clause D of the Protection of Human Rights Act as the rights relating to life, liberty, equality and dignity of the individual guaranteed by the Constitution or embodied in the international covenants and enforceable by the courts of India. So, it is evident that courts have a major role to play in enforcing the rights. Working towards the protection of human rights ought to be the paramount goal of any court of the country. Some barriers which are believed to be set aside. First, avoidance of the legal system due to economic reasons or fear. Second, excessive number of laws. Third, expensive legal procedures. Fourth, inadequate legal aid systems. Fifth, inadequate information about laws, the rights arising out of them, and the prevailing practices. Sixth, failure of legal system to provide remedies which are preventive, just, non-discriminatory and adequate. 7. Lack of public participation in reform movements. The right to enforce the human rights provided in the Constitution of India is protected through enabling provisions. Article 226 of the Constitution empowers high courts to issue directions, orders or writs for the enforcement of fundamental rights as well as any other legal rights. Article 32 itself a fundamental rights invests the Supreme Court with the power of judicial review for the enforcement of fundamental rights, with the power to issue direction, order and writs as well. The Indian judiciary, with its widest interpretation in observance of human rights, has contributed to the progress of the nation and to the goal of creating India as a vibrant state. The intervention by the court for issues involving the economic, social and cultural rights definitely created a positive implication. The district judiciary renders an active role in dispensing of justice. They have a massive duty to protect the constitutional rights of the citizen. Barring few limitations, the district judicial officer are in charge of all matters, including application and interpretation of constitutional provisions like Article 14, 19 and 21, etc. It is after the appreciation of work done by the district judicial officers that the legislature enacted the Protection of Human Rights Act 1993. One of the main objectives of the Protection of Human Rights Act 1993 is to establish the human rights courts in every district level. Section 30 of the Act enables the state government to specify for its district a court of sessions to be a human rights court after the due concurrence with the Chief Justice of the respective high courts. The motive behind the provision is to provide speedy trial of offences arising out of violations of human rights. The creation of human rights courts at the district level has a great potential to protect and realize human rights at the grassroots level. But unfortunately, this court, designated as Human Rights Court, did not function for a pretty long time. The reason is known to all that the rules of practice for the Human Rights Court were not formulated dealing about procedures for taking up complaints from individuals, penal provisions for punishing the guilty persons. The Act refers to the offences arising out of violations of human rights, but it does not define or explain the meaning of offences arising out of violations of human rights. It is vague. The Act does not give any clear indication or clarification as to what type of offences actually are to be tried by the human rights courts. No effort are made by the central government in this direction. Unless the offence is not defined, the courts cannot take cognizance of the offences and try them. Till then, the Human Rights Court will remain only for namesake. Even if offences arising out of violations of human rights are defined and clarified or classified, another problem arises in the working of the Human Rights Court in India. The problem is who can take the cognizance of the offences. What the Act says is in its districts, one sessions court has to be specified for trying offences arising out of human rights violations. It is silent about taking up cognizance of the offence. The Prevention of Corruption Act 1988 is another law which provides for appointment of a session judge in its district as special judge to try the offence under the said Act. Provision has been made in Section 5 of the Prevention of Corruption Act 1988 empowering the special judge to take cognizance of the offences under the said Act. In the Protection of Human Rights Act 1993, it is not so. Under the Criminal Procedure Code 1973, a session judge cannot take cognizance of the offence. He can only try the cases committed to him by the magistrate under Section 193 of the CRPC. Similar problem had arisen in working of the Scheduled Caste and Scheduled Tribe Act 1989 in the beginning. The special judge used to take cognizance of the offences. In Potluri Purnachandra Prabhakar Rao versus State of Andhra Pradesh 2002, Clause 1, Criminal Court Cases 150, Ujagar Singh and others versus State of Haryana and other 2003, Clause 1, Criminal Court Cases 406 and some other cases, it was held that the special court does not get jurisdiction to try the offences under the Act without committed by the magistrate. The Supreme Court also held same view in Moli and other versus State of Kerala 2004, Clause 2, Criminal Court Cases 514. Consequently, the trial of all the cases under the Prevention of Atrocities Act were stopped and all the cases were sent to the courts of jurisdictional magistrates. Thereafter, the respective magistrate took cognizance of the cases and committed them to the special courts. The special court started trying the cases after they were committed to them. The Act was later amended, giving the special court the power to take cognizance of the offences under the Act. The situation in respect of the Human Rights Court under the Protection of Human Rights Act 1993 is not different. Apart from the above, the special courts will face yet another question whether the provision of Section 197 of CRPC are applicable for taking cognizance of the offences under the Protection of Human Rights Act 1993. In most of the cases of violations of human rights, it is the police and other public officers who will be accused. The offences related to commission or omission of the public servant in discharge of their duties, definitely the accused facing the trial under the Act raise the objection. There are plethoras of precedents in favor of dispensing with the applicability of Section 197 of CRPC on the ground that such acts like the one which result in violation of human rights do not come within the purview of the duties of public servants. But there is a scope for speculation as long as there is no specific provision in the Act dispensing with the applicability of Section 197 of CRPC. The object of establishment of such courts at district level is to ensure speedy disposal of cases relating to offences arising out of violations of human rights. Unless the lawmaker take note of the above anomalies and remove them by proper amendments, the aim for which provisions are made for establishment of special court will not be achieved. On 9 September 2011, the West Bengal government was the first to set up human rights courts in all 19 districts of the state to ensure speedy disposal of cases concerning human rights. This court functions from the district headquarters and it is under the district session judge. Separate public prosecutors are being appointed in each district human rights courts as provided by the Section 31 of the Protection of Human Rights Act 1993. More and more sessions courts must be specified as the human rights courts for achieving the full benefits from the Act. In the present era, the human rights refer to more than mere existence with dignity. Judiciary is the only organ which can translate these rights into reality, which is not possible without the help of the judicial officers of the respective courts. The Indian judiciary is playing a role incomparable in the history of judiciaries of the world. It must, therefore, prove itself worthy of the trust and confidence which the public reposes in it. The judiciary must not limit its activity of the traditional role of deciding dispute between two parties, but it must also contribute to the progress of the nation and the creation of a social order where all citizens are provided with the basic economic necessities of a civilized life vis-a-vis employment, housing, medical care, education, etc., as this alone will win for it the respect of the people of the country. Thank you.